Hey everybody, it's your man, Dr. L, and what we're going to discuss today, we're going to discuss a case that I think that everybody should really be familiar with. If you are concerned about the excessive use of force used by police officers, in particular the use of deadly force, and this is the case that you really want to understand. This was a case that was recently decided in a 9-0 decision. That means all Supreme Court justices, all 9 of them, agreed that this is the situation, or that this is the way that the law enforcement should act going forward. So let's take a look at this. And in this, I also do expert testimony work, so it's very necessary for me to understand these types of laws and principles and the application and the use of force. Therefore, when I go testify in courts, I will be able to help and assist the attorneys, or whichever side is hiring me, in order to get the best results for the case. So I'm going to give my expert opinion on how police officers do or should behave when they are in the line of duty. So this is a fairly recent case, and this case is called Barnes versus Felix. I'll get into that in a little bit, but I want to explain how the court system works. First of all, whenever someone wants to sue an agent of the government, in this particular case, it's usually law enforcement, right? So you want to sue a police officer because you believe that your rights were violated, or, and God forbid, that one of your loved ones had their life taken by the hands of the police. That's a city police officer. You want to be able to have some type of redress, and that redress comes through the court system, right? We don't engage in barbary where we just go out there eye for an eye and type of stuff. So our redress, our course of action, is to get a monetary compensation many times, and sometimes even to change the way that the rules and the laws go. And this is an example of that case. Tennessee versus Garner, Graham v. Connor, or all other examples of excessive uses of force in which the persons not only got monetary compensation, but they also had some laws and rules changed, and therefore the conduct of how police officers engage in what they do. So in this particular case, so let's just take a look at the map right here. So first, you want to sue a police officer, right? So you want to sue a police officer, and what happens is you go to a court and you do whatever you got to do, hire a lawyer, whatever you're doing, try to do it yourself. You sue the police. And then if you're unhappy with the case, then you go to an appellate court. And this would be what we call district courts or appellate district courts. So this is the map of how they would work. So if you live in, let's just say I live in district number 2. So any laws that are any rules or judgments that the appellate court, because the appellate court will look at what the lower court has done in order to come to the determination that they did. When you hear court cases, you see court cases on TV, and they say, I object. One of the attorneys yells that out or whatever. The judge will then say it's either overruled or it's sustained. In either case, they are setting the groundwork for, they being the attorneys, are setting the groundwork for that they can go against or challenge the rulings or whatever procedural errors that they deem to be fit at the time that they yelled objection, and they will take their objections to the higher court, which would in this case be the appellate court. Okay, now they get to the appellate court, which means appeal. I appeal to a higher authority. So they're appealing to a higher authority. Those appellate judges in those district courts will lay out parameters and lay out rules and regulations that that the whole that we saw jurisdiction number 2, jurisdiction, if you live in jurisdiction number 1, jurisdiction number 5, or appellate district number 5. This is how everyone in those situations is going to all police officers and anyone in that particular industry is going to affect, right? So this is how we get, how rules are governed and how police officers go about their daily business. Not only comes from it comes from court cases, and it also comes from their individual policies and procedures from each individual city. That's a story for another time. I don't want to make this too long. I'm just trying to give a brief overview of what goes on. So then, if you're unhappy with the appellate court, you can appeal then to the United States Supreme Court. There is no higher authority in the United States Supreme Court. Whatever they decide, that's the law of the land. So because one of the most famous cases regarding law enforcement would be the Miranda decision. All officers, before they engage, all officers across the United States and all its territories, before they engage in interrogating a suspect, has to Mirandize the suspect. And that means they have to tell them and prove to them, prove to the court that they have read their rights. What are the rights? That they have the right to remain silent. They don't have to speak to anyone. They have the right to an attorney. If they cannot afford one, then sometimes depending on the case, an attorney will be afforded to them. Right, so they had to be acknowledged. They had to have these rights read to them, and they had to be acknowledged, and all that. That's a whole other story for another day. But we get the word Mirandize from the last name of the person who it happened to. It was Miranda versus Arizona, or Arizona versus Miranda, whatever. So that's how we get to that. So that's a famous case. This is, in my estimation, going to be another one of these big prominent cases that's going to deal with law enforcement. All right. There was another court case that was recently decided involving the birthright citizen debate that's going on. Let me add this to the stage here. So, what the court ruled in this particular case is that anything, these federal judges were trying to, whether they were trying to or not, in effect, were doing exactly what the Supreme Court should be doing, and that they were saying that if something happened in one district, and that was applicable throughout all the United States. And so what the Supreme Court said in this particular case is, no, that's not the case. We set law and set precedent. I'm adding my own little terminology there, but we set law and we set precedent. But lower federal courts don't have the ability to do that. So it's great that sometimes they do that, because to my knowledge, there has been no SCOTUS, Supreme Court of the United States, decision on the use of video cameras, to my knowledge. Could be wrong about that. But what we have is different appellate courts, higher district courts, all saying, people can film the police as long as they are, not interfering in some way. But I don't believe that has been codified by the SCOTUS, Supreme Court of the United States. So what the Trump decision did in this particular case is they said, hey, here's what we need to do. We need to make sure that we clamp down on other people doing it. Now, they may actually get to the actual case as far as birthright citizenship, and that we may have a decision about that soon. But that's all they decided thus far. You can watch other YouTubers who have a far greater grasp on that than I. But I wanted to discuss this case and how it goes on, how it deals with law enforcement. So let's look at the case of Barnes versus Felix. All right, so we'll add this to the stage here. And we'll do this one, right? Okay. This is not the one. Add this to the stage. Add this to stage. Remove that one. Add to stage. What is up with? Oh, here it is. Okay. Jeez. All right. So Barnes versus Felix, which was decided fairly recently, right? Says this is May 25th, 2025, Justice Kagan delivered the opinion, and here's what she said. A police officer's use of deadly force. We'll scroll down a little bit. We'll scroll down and read this here. Right, so here's what happened. On the afternoon of April 28th, 2016, Roberto Felix Jr., a law enforcement officer patrolling a highway outside of Houston, received a radio alert about an automobile on the road with outstanding toll violations. Felix spotted the car, a Toyota Corolla, and turned on his emergency lights to initiate the traffic stop. The driver, Ashton Barnes, pulled over to the highway shoulder, right? So semi-routine motor vehicle stop, right? Toll violations. He's going to get this guy and pull him over. Parking his own car behind Felix, as all police officers do most of the time, most of the grand majority of the time. Felix walked to the Corolla's driver's side door and asked Barnes for his license and proof of insurance. Barnes replied that he did not have his license with him and that the car was a rental in his girlfriend's name. As he spoke, Barnes rummaged through some papers inside the car, causing Felix to tell him several times to stop digging around. Right? You already told me you don't have a license. Is already, from police officers' safety perspective, this is already starting to go awry. I don't know who you are. You don't have your proper paperwork. You're fumbling around for stuff, telling you to stop digging around. I don't know if you're looking for a gun. I don't know if you're trying to waste time and try to prepare for a fight or flight situation. These are all things that officers are trained to do. Felix also commented that he smelled marijuana and asked if there was anything in the car he should know about. Barnes responded that he may have some identification in the trunk. So Felix told him to open the trunk from his seat. Barnes did so while also turning off the ignition. All that happened as a dash cam recording on the incident shows in less than 2 minutes. So I want to go back to here to the time frame here. So this is 2016. This is occurring. It's 2025. Almost nine years since this. This is how long it takes to get through courts, and so we can get a decision. Right? Can we? Let me ask you this: Can police officers still ask people to do things when they smell marijuana? Depending on your jurisdiction where you live, right? This is how old all of this stuff is, and how long it takes to get to these certain levels of decisions, right? So Felix told him to open the trunk from his seat. Barnes did so while turning off the engine. All that happened as a dash cam in less than 2 minutes. Can they open up? This is where we get into different appellate courts, district courts, rules, regulations, different state laws is about whether you can ask people to open up trunks and all that kind of stuff, right? I'm not going to dig into that. Then things began to move even faster. With his right hand resting on his holster, Felix told Barnes to get out of the car. Barnes opened the door but did not exit. Instead, he turned the ignition back on. Felix unholstered his gun, and as the car began to move forward, jumped onto its door sill. He shouted twice, "Don't effing move," with no visibility into the car because his head was above the roof. He fired 2 quick shots inside. Barnes was hit but managed to stop the car. Felix radioed for backup. By the time it arrived, Barnes was deceased. All told, about 5 seconds elapsed between when the car started moving and when it stopped. Remember, this was called a videotape. And within that period of time, 2 seconds passed between the moment Felix stepped out on the door sill and the moment he fired his first shot. Barnes' mother sued Felix on behalf of the suit brought under 42 U.S.C. 1983. Maybe I'll discuss that in another time, but certainly a lawyer would do a better job discussing that than I can. Alleged that Felix had violated Ashton Barnes' Fourth Amendment right to excessive force. The court granted summary judgment to Felix. That's the officer, right? Summary judgment means that they said what he did was okay. The court explained that to prevail on her claim, Ms. Barnes needed to show that Felix's use of force was objectively unreasonable. In the usual excessive force case, the court noted that the inquiry into reasonableness would involve considering a variety of circumstances. That when an officer used deadly force, the court continued, the Fifth Circuit, remember I talked about the circuits, has developed a much narrower approach. Then a court could ask only about the situation existing at the moment of threat, right? So this is where the Fifth Circuit differentiated themselves from the other circuits because they looked at the moment of threat. That was the operation of the time. That was how officers operated at the time within the Fifth Circuit, and they were completely justified in doing so. That sparked the fatal shooting, right? And here's some court cases to kind of go about that or expand upon that. The district court identified the moment as the 2 seconds before Felix fired his first shot. In other words, what they didn't look at the totality of the circumstances, the whole encounter. What is the whole encounter? What happened? Popping the trunk, opening up the door, asking him to get out, jumping on the sill of the car. Right? Did you have to do any of that? What did we want it for? What did you want this man for? It was a toll violation, and possibly not having a driver's license and any identification on him when you're operating a motor vehicle. This is what he's wanted for, right? Is it okay to take someone's life if that's what they're wanted for? The district court identified that moment of the 2 seconds before Felix fired his first shot when he was standing on the door sill of a moving vehicle. At that moment, the court found an officer could reasonably think himself at risk of serious harm. And under the Fifth Circuit's rule, that fact alone concluded the analysis. That was the end of the story. The court explained that it could not consider what had transpired up until then, that it could not. The court explained that it could not consider that until the last 2 seconds, including Felix's decision to jump on the sill. Although a more robust examination might have aided in the assessing reasonableness of the shooting, the court was duty-bound by the circuit's precedent to limit its focus to the exact moment of that. So because this is codified in law, this is what they're saying. Because this was the precedent, this is what we've always judged everyone on. This is what we're going to deal with, right? Okay, so the court affirmed the Court of Appeals affirmed, explaining that it was bound by the circuit court's moment of threat doctrine, right? So the first court, the federal judge they went to, said this is what they're going to do. The Court of Appeals, as I showed you that, showed you that map, I should say, said, hey, yeah, here's what we're going to do, and they said that this was right. Under that rule, the panel agreed the inquiry is confined to whether the officer, any prior events leading up to the shooting, including actions the officer took, were simply not relevant. And here, as the district court found, the precise moment of threat was the 2 seconds when Felix was clinging to the moving car. Because Felix could then reasonably believe his life was in danger, the panel concluded his decision to shoot, but did not violate Barnes's constitutional rights. Okay, so we're going to go back up here, and we're going to read what the decision was, right? So here's the syllabus here, right? Respondent Roberto Felix, a law enforcement officer, and this opinion is by Kagan. Okay. A respondent, Roberto Felix, a law enforcement officer, pulled over Ashton Barnes for his suspected toll violations. We read all that. Barnes' mother sued Felix on behalf, alleging that Felix violated Barnes' Fourth Amendment right to excessive force. That's a search and seizure. The district court granted summary judgment to Felix, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat requires asking only whether an officer was in danger at the moment of the threat resulted in his use of force. Under the rule, leading up to the shooting, events leading up to the shooting are not relevant. And this was held, right? This was held. Most notably here, the totality and circumstances inquiry has no time limit. While the situation and the precise moment of shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later actions. So in other words, this is the justices, the Supreme Court, disagreeing, right? Prior events, because this is what we call the totality of circumstances. Totality means everything. Totality means everything, not just that particular moment of incident. Or what was the word there? Moment of threat, right? Not just that moment, but everything. Prior events may show why a reasonable officer perceived otherwise ambiguous conduct as threatening or instead of innocuous. Well illustrated this Plumhoff v. Ricard well illustrates this point. There, an officer's use of deadly force was justified at the moment, partly because of what had transpired in a preceding period. So you got to take the preceding period into account. The moment of threat rule applied below prevents that sort of attention to context, and thus conflicts with the court's instruction, that would be Supreme Court's instruction, to analyze the totality of circumstances. You can't violate the Supreme Court's totality of circumstances. By limiting their view to 2 seconds before the shooting, the lower courts could not take into account anything preceding that final moment. So, for example, they could not consider the reason for the stop or the earlier interactions between the suspect and the officer. And because of that, they could not address whether the final 2 seconds of the encounter would look different is set within a longer time frame. A rule which precludes consideration of prior events in assessing a police shooting is not reconcilable with the fact-dependent and context-sensitive approach this court has prescribed. A court deciding a use of force case cannot review the totality of circumstances if it puts on chronological blinders. In other words, if you're going to look at the totality of circumstances, that's the complete interaction between the law enforcement up until, unfortunately, they're taking someone's life. You can't just say, okay, we're going to stop at 2 seconds and ignore the other 10 minutes of interaction. Can't do that. That's not the totality. The court does not address a separate question about whether or how an officer's own creation of a dangerous factors into a reasonable analysis. The courts below never confronted that issue, and it was not the basis of the petition. Vacated and remanded. In other words, they had to go back. They're going to kick this back down to the court and told them to go back and take a look at this from the totality of the circumstances, from the beginning of the stop to the end. That what they're not going to address or not being allowed to address is the creation of a dangerous incident situation. So now they might be able to so what the lower court is going to do, let me stick to one point thing at a time. What the lower court is going to do is they're going to address the totality of circumstances. Did he have to jump onto the windowsill, et cetera, et cetera, et cetera? So that is not the windowsill, the door sill. So that is what they're going to take a look at. Also, what the judge in this particular case also made note of is that we're not going to look at the creation of a dangerous situation. So it may come back that this is kicked down, and they'll say, okay, we don't like this case, or they being the family will say, okay, we still don't like the case because we think that the officer created a dangerous situation. We think that his actions are what precipitated and therefore necessitated the taking of our son's or our loved one's life. That may be something that lawyers might want to consider in the future. I don't know. I'm not a lawyer. So I just wanted to kind of drop this here so we can have a better understanding of why this is important and what law enforcement officers' takeaway should be. So law enforcement officers' takeaway should be, and for you as the general public, if you're watching this, should be, what are the entirety of the actions, the totality of the circumstances from the time that the engagement begins, whether it's a motor vehicle stop, whether it's you stop someone in the park after dark, whether you stop someone in the street interview, whatever the totality of the circumstances are, they more than likely, they being, your agency, your state, your district, are going to look at the totality of circumstances and ask what a reasonable officer should have known and how they should have acted. What similar officers across the country who was reasonably trained, similarly trained, what actions would they have taken? Would they jump on the door sill of a car? We don't know, because that's a dangerous situation that they're putting themselves into, right? You're putting yourself in that situation. Would you dig into someone's pockets you're not supposed to, right? So they're going to look at all that. So I just want to drop this real quick. Let me know your thoughts and your opinions. Do you think this is helpful? Remember, this was a 9-0 decision. Anything that's a majority is the decision. So it can be 5-4, 6-3, 7-2, 8-1, 9-0. So in this case, it was a 9-0. So all justices, all conservative, and the 3 liberal judges all agreed we got to look at the totality of the circumstances. Conservative judges said this as well. So very, very interesting case. Let me know your thoughts and your opinions. If you have any other case that you think involves law enforcement that you really don't understand, let me know. If you have any videos you want me to review, let me know. Do me a favor, hit the like button, give me a sub. I would really appreciate it. Much love and peace.